Initial reaction to the dismissal of the recusal application?
Well, it's entirely predictable because both the law and the facts was against Mr. Zuma and his lawyers. For some of them, which you pointed out, that it's actually very difficult to prove that there is a reasonable apprehension of bias, that the onus was on the former president, and that burden was not even remotely met.
Right.
So this doesn't come from a legal perspective, not in any way as a surprise for me.
Remind us, sir, what the test for bias is.
Yes. So the test is not whether Mr. Zuma himself feels that there's bias, or that he feels uncomfortable to testify, or that he thinks that people are against him and there's a conspiracy. It's what would an objective, reasonable person on the correct facts, not conspiracies, correct facts, would believe. Would such a person, in fact, believe that the Judge Zondo is not able to consider the evidence, keep an open mind, and make an assessment on the evidence that comes before him? In other words, has he already made up his mind about everything that is coming before the commission?
Right.
And that's a reasonable person's view that is at play. That's not an easy standard to meet, especially not given the way in which Judge Zondo has dealt with the commission so far.
So let's get to what happened after this ruling. Zuma's legal team intends, they say, to excuse themselves. With the summons still in play, what consequence will this have?
Well, if they just excuse themselves without Judge Zondo permitting this, they will be contempt of court. So that's a criminal offense, and former President Zuma could be arrested if he just walks out and refuses to testify, because you cannot do that. So we have to wait and see what Judge Zondo does now. But I was quite shocked that the lawyer said they're just going to excuse themselves, because you cannot just ignore a summons. That is a legal obligation that you have. That's why they are before the commission at the moment.
Right. They mentioned something about staying the matter and then the judge then deciding. Now, if the judge comes and says, look, this needs to go ahead, then you have this, they didn't want to put it as a walkout, but they're excusing themselves. That's how they put it. What immediately happens then in terms of law enforcement getting involved? Is it how we think it's going to play out?
Well, I have no idea, because this is a completely unique situation. It's the President Zuma and his lawyers are really playing a high-risk game of sort of playing chicken, if you will. I don't know what will happen practically. What they might do is they might urgently approach the court for an interdict to stop the proceedings, or to suspend the summons, or whatever the case might be. I don't know. I have no idea whether they will go that route or not. But if they just leave and they have no permission from the judge, they do open themselves up to a contempt of court criminal conviction.
Right. So the review that Zuma's counsel was talking about, that's another court proceeding.
Yes, so that's another court proceedings. Once again, if the review can go ahead, that is not legally impediment to the testimony going ahead. So if Judge Zondo wants to, he can force the former president to continue with the testimony until such time as there's an interdict suspending this, if there will be, or until such time as the review has been completed, and we'll see what the outcome of that is. I think the chances of the review being successful is very small.
Another intention from Mr. Zuma's counsel, they intend to lodge a complaint with the Judicial Service Commission. Part of the complaint was that Deputy Chief Justice made himself a witness as well as a judge. Any merit in there?
Yes, there's already constitutional court jurisprudence, which were actually mentioned by Judge Zondo, where judges of the constitutional court, in fact, made themselves witnesses by giving statements about this is actually what happened. Judge Zondo followed that constitutional court precedent. So I am a little bit surprised that there would be this approach to the Judicial Service Commission. I cannot believe that it is done for legal reasons reasons, there must be other reasons, because that complaint is not going to go anywhere. I can put my hand on the Constitution that it will be dismissed.
Right. Do you think there's a lack of appreciation of the duties of the chair in an inquisitorial setting, as Advocate Pretoria has put it? Because my understanding is that this is not an adversarial process, such as a criminal trial or a civil trial, where a party remains silent and the other party wins. This is different.
Yes, this is different, although I don't think in the end that made such a big difference. But obviously, if you are in an inquisitorial process, the presiding judge plays a much bigger role. He's not so passive, as Judge Zondo also said. He has to actually test the evidence. He has to direct people to find more evidence if he thinks that they need to. So it's a completely different role. But even if it was a criminal trial and the application was brought, I cannot see that any judge would have recused themselves on the facts that was presented by Mr. Zuma and his lawyers, because it didn't rise even to the beginning of a suspicion of bias.
There's a principle that you obviously will be very familiar with, but for the purpose of the audience, how important is it that not only must justice be done, but also justice must be seen to be done?
Yes, so that is very important, of course. So, and in this case, for a commission of inquiry, much depends on the legitimacy of the process, because the outcome is going to be legitimate if people perceive the process to be legitimate. That is why I think one of the reasons why this application was brought, because it is not in President Zuma's interest that this is perceived as a legitimate process. But that's also why there's a possibility for recusal, because if there's really an apprehension of bias and the judge continues and with the proceedings, then people will start being suspicious about the process. So that is important. That is why it's important to deal with these matters very carefully and to actually recuse yourself, but only where there's actual strong evidence to show that a reasonable person would believe you are biased.
Right. Let's look at possible scenarios here. It's, just on the top of my head, what might happen. If the Deputy Chief Justice comes and says things need to continue, then you have this Mr. Zuma's team excusing themselves. Mr. Zuma is then arrested. He's either charged, then he either faces a fine or a prison term, possibly. I'm not sure. You can correct me if I'm wrong. After all that has happened, for example, is this matter put to bed? If he has to go through all that process, does he have to then come back here?
Yeah. So if there's a subpoena, and if the subpoena is valid, it's not challenged or overturned, then the former president has to testify. Right. Of course, practically, it's very difficult because it's very difficult if the former president comes to the commission and he just meanders along and he doesn't actually give any evidence, he can probably get away with that. But of course, it will not be good for his credibility, and that would not be very good, but that is a possibility. The process can drag on. We can see that this has been dragging on for 2 years. But in principle, if there's a subpoena, if the subpoena stands, he cannot ignore it without being on the wrong side of the law.
Right. What's your gut telling you, sir, with regards to what happens next, what the Deputy Chief Justice might say?
I really don't know. And I've also learned that as a lawyer, one must not always trust your gut. So I'm not going to answer that.
All right. Thank you very much indeed for your time. No doubt we'll have you back to get your perspective on things. Appreciate it. Constitutional law expert, Pierre De Vos there. Thank you. All right, let's take a quick break.